All right, so we get into two crucial issues as we talk about the political ping pong between the NDC and the MPP. I did better, you fared worse, and all of that. We'll get into that, but we'll start by talking about the injunction application, interlocutory injunction, which has been thrown out by the Supreme Court by a unanimous decision of 7-0. How do things pan out? People have sent in messages this morning saying that the NDC is not doing enough in court. But is that the reality? We're joined by one of the core members who put this petition forward at the Apex Court, Mahama Ayariga. He joins the conversation. A very good morning to you, Mr. Ayariga.
Good morning.
Thank you so much for joining the conversation. Thank you for being with us this morning. And let me also start by apologizing for keeping you waiting.
That's okay.
All right. Mahama Ayariga is also member of Parliament for Boku Central. What is your reflection following the motion you put before Parliament to stay the process of the E-Levy? The rollout was started, and then we were told yesterday in the ruling delivered by the Apex Court that it would have caused great harm to the state by putting or accepting that injunction, and for that matter, as one of the ratio may not be out, but on taking note of that, your injunction has been thrown out. How do you feel about that?
It's unfortunate. We were very confident that the court will balance things more in favor of the Ghanaian public,
right,
than the government. Precisely because we think this is a constitutional matter. And being a constitutional matter, I think it shouldn't be about the money per se. It should be about the principle that law is being passed in violation of the Constitution. So we were expecting that the court will rather injunct government and wait for us to resolve the issues expeditiously. I don't think that it is practically possible that if several millions of Ghanaians through several million transactions get their monies deducted, the GRA has that infrastructural capacity, the technology, to be able to reverse and refund the monies. I mean, as we speak, because of the technological challenges in implementing this e-levy, they are staggering it. So that is an admission of the technological challenges involved in implementing this legislation. So I do not see how it is going to be easy to reverse the transactions several weeks or months after the monies have been collected. So I thought that the balance would have been in favor of holding on with the implementation of the levy, and then subsequently, depending on how the matter is resolved, we don't know the way forward. But the court thought otherwise and ruled against us. We are bound to follow the decision of the court.
You're going to follow the decision of the court. In my earlier interaction on the news review, I noticed some people sending in messages that for you, the NDC, you are not doing enough in court, that the AG seems to come clothed with facts and figures and the right things, following the right processes in court, but that you as the minority, you're not getting things right in court. That is why you keep getting 7-0, 9-0, and other results in court. Is that the real picture?
Well, I mean, the AG really has done nothing in court. The AG has not even filed their statement of case in response to our statement of case. They have not. They only filed an affidavit in opposition to our our statement, our rate, and our application for interim injunction. And so they've really not taken any significant step. They only opposed the injunction application, and the argument was simple, that more harm will be caused to the state than to we, the applicants, and a very simplistic argument that if the GRA did not take the money, it is more likely that they will lose the money forever if we don't win. But if GRA took the money, it's more likely that the money can be refunded to citizens if we win. So
you call it simplistic. Does that mean it is not logical for you? Because the word simplistic itself has its own meaning. So are you saying that you feel it wasn't a well-reasoned decision?
Well, I mean, the argument is quite simple, isn't it? And I'm responding to the criticism that the AG was there back with figures and this and that. I mean, there were no figures. I mean, basically, it was just the simple argument, and the court bought into it against our argument that harm will be caused to the Constitution if a law that is not consistent with the procedure for passing laws is allowed to be implemented when its legality is being determined in the Supreme Court. So honestly, I mean, this is a very simple argument. Even though the court bought into it in its simplicity, you can't deny the fact that it's quite a simple argument. And that was what the court bought into. So we are doing all that we can. People shouldn't forget that the minority with a lower number in Parliament fought E-Levy for 5 months. It took the NPP going to the High Court, the Court of Appeal, and ultimately to the Supreme Court to disable one of our colleagues.
Hello, Mr. Ayariga, are you there?
Which undermined our numbers when they went to court and then disabled one of our colleagues. And that was what weakened.
You're referring to James Jatikwese.
Yes. So that undermined our capacity to keep fighting in terms of numbers and to resort to a legal strategy.
Right.
So we will keep fighting. I don't want to impute any ill motive to the bench. I don't want to say that the unanimous decision of the court, is informed by any other consideration beyond their appreciation of the law. But the substantive matter has not been
and we'll get to that
resolved.
Respectfully, Mr. Ayariga, we'll get to that shortly. But
yes.
Were you disappointed that here was another unanimous decision against you? I mean, if there had been a bit of a change of sorts, would that have carried some favor with you? Would that have been more placable for you if it hadn't been another 7-0 result in court?
Well, I mean, anytime that you have some dissent and there are one or two judges agreeing with you, it gives you some satisfaction, even though the ultimate satisfaction is when you win. But again, if they are unanimous, there isn't much you can say beyond just, as a lawyer, coming to a conclusion that they were probably all agreed on their position, and that is it. I'm not one of those who like to criticize judges on radio and on television. As a lawyer and an officer of the court, I think that it will be unacceptable for me to be criticizing judges. I should focus on the judgment and not the judges.
Let me put this quote to you and ask you about what next you'd be looking at. As per the Daily Graphic this morning, and as the court stated, if the E-Levy is declared unconstitutional and thus null and void, the sum deducted could be refunded by the GRA. On the other hand, if the levy is injuncted by this court and at the end the applicants fail in their substantive case, the GRA will be unable to recover the levies applicable. That is very rational, right?
To be frank with you, I am not about to fight the simplistic conclusion of the court. I just believe that, knowing the way our institutions function, that that is a very remote possibility, that the GRA will ever be able to refund to several millions of Ghanaians the deductions that may run into several millions, because people transact on a daily basis. Sometimes one person can transact 10, 20 times a day, and multiply by several millions of people transacting over several weeks and possibly several months, depending on when the court concludes this matter. I doubt if GRA has the technological capability of reversing and reimbursing people. I mean, what has been the track record of this country in terms of tax refund? What has been the track record? And in court, we argued. We said, look, even last year, the Auditor General, reported that monies kept in the accounts of GRA meant for refunding taxes, has been misapplied. We argued that in court based on the Auditor General's report. And we said, look, this country's track record in terms of tax refunds is not the best. So you can't count on that.
Mr. Ayariga, let's put this into context. The EMIs who are handling this as it is now for the telcos, you have Mobile Money Limited, for example, for MTN. They have started the process already of doing this. In fact, I am looking at one such refund which was shared with me yesterday, and it says payment received for 75 pesos from E-Levy Refund's bulk account. The date, the 4th of May 2022. The time is there, and the person's current balance and everything is shown there. So what really is the problem? Because they have shown commitment to the fact that if people, it is confirmed that the E-Levy should have never stood, people would get their refunds. So where lies the problem?
That is, if the money has not yet been squandered. You see, if the court has said that the telcos should collect the money and keep it until we have resolved this matter,
right,
and then they can then pass it on to government if government is the winner ultimately. But they haven't said that. In fact, what they have said is that government can collect the money, government can use the money for development purposes, and if finally we conclude this matter and then it is in our favor, government will refund the money that they would have already squandered. I mean, look at the level of indebtedness of government to the international financial system, to our domestic banks, to bondholders, and etc. Look at the level of indebtedness. If they take this money and they squander it, how do you expect that they will find the money to refund to
Mr. Ayariga,
to people? So if they had said, oh, this money should be kept in a special account, so that when this case is concluded, we will decide where it should go to. That would have provided some greater security for this money.
So just to clarify,
pardon?
Just to clarify, so it means you would have been satisfied if they had given this alternative that you can collect, but let it be in some pool and not be expended until the substantive case is looked at.
I don't believe in the security of this money if it already gets into the hands of government and government utilizes it, and then we come and say they should refund. I mean, government is already reeling under huge debts, huge obligations and liabilities that they cannot handle. They are looking for money everywhere to borrow to deal with current expenditure. And then you now burden them with a refund of several hundreds of millions of cedis, presumably. I mean, you will be asking for the impossible.
So tell me, it means that what you're saying is you are afraid, as of this point, that should the court even rule in your favor, government would not be able to refund the money.
I doubt if they
I didn't quite catch that, Mr. Ayariga.
ruled in our favor. I would just be happy that they have ruled in our favor, and then we will stop collecting the monies. But as for what has been collected, I doubt if it will ever find its way back to the Ghanaian citizens. And that is where I think the court might have miscalculated.
The court might have miscalculated. Right. How optimistic are you that, the other case, the substantive case, could go your way?
Very optimistic, very optimistic. I think that when they go into the issues and they do some more research in terms of the workings of Parliament and apply it to the interpretation of the Constitution given by they themselves in the Justice Abdullahi case, they will realize that the requisite quorum at the time of taking decision was not there. I mean, very simply put, the Supreme Court said you have to be 138. The AG argues that at the time of taking the decision, the requisite quorum was 137. Let's even assume that the AG's position is right. The facts are that the decision in Parliament was taken by a voice vote. It is clear, there's clear evidence that one MP who was sick and was in the clinic of Parliament was not in the chamber. And so the majority could only have had 136 people in the chamber at the time of the voice votes. So his voice was not added to the voices. So clearly, there were only 136 in the chamber at the time that they took the decision, in clear violation of their constitutional position that they needed to be 138. And even if we took out question and the overall number of parliamentarians reduced, they needed to be 137. So if they really are true to the facts and faithful to the facts of what happened in Parliament, this case should go in the favor of the applicants. Okay.
Tell me, let's go back a notch. When you look so far at the implementation of the E-Levy, with what we've seen, people being charged where they shouldn't be charged, refunds now going in, the fact that until July, we're not going to see a full integration of the EMIs into that, singular grid and all of that. On a scale of 1 to 10, how would you rate this rollout as it is, as of today?
I'm not among those who are interested in the discussion of the rollout. I take a position that it is illegal, unconstitutional, should not be accepted, should be stopped, and that is why we are in court. And so I'm not about to discuss the rollout. If anything at all, these challenges point to the weakness in the court's decision that, they should deduct and later on there will be a refund, because these current challenges show that there will be technical challenges in implementing a refund order of the court.
Let me ask you this bit. So your flag bearer in the past election, has said that should your party come to power again, you will scrap the E-Levy. Looking at all these dynamics and the situation, we find ourselves in, even if you inherited this economy, would that be viable? Would that be prudent to do? Is that something you actually mean to execute as a party?
Of course. It's a commitment that our party is making. And the former flag bearer is definitely a key spokesperson of the party. And what he says reflects the thinking of the party. So I can assure you that, as promised, the NDC will scrap it. And it is viable because every indication is that our current crisis is not informed by the lack of adequate taxation. A lot of it is a function of our failure to collect the tax that is already due. And, wastage. And if we just take the Auditor General's reports and we address the concerns expressed in the Auditor General's report, if we cut down on waste and we cut down on inefficiency and we are aggressive in terms of tax collection, we will make up for the amounts of money that E-Levy is going to rake in without doing the damage to the overall economy that e-levy will do. One major drawback of this, our economy, has been its informal sector. And over the years, digitization investments has aimed at bringing in the informal sector into the formal sector by digitizing them, recording them, and getting them formalized.
Right.
What e-levy is going to do is to drive all of them away, or a majority of them away. So all the investments we have made into trying to capture the informal sector will suffer a terrible blow. And yet the amount of money that we're going to take from e-levy will not be able to make up for that loss. So net-wise, we're going to lose.
Okay. Mr. Ayariga, right. Just do me a favor, hold for me, briefly, hold for me. I have a final question for you, but not to answer now. Just reflect upon it as I bring in another guest who joins the conversation. When I come back to you, Mr. Ayariga, I would want you to address your alternatives. If you take out the e-levy, what would be your replacement, or how would you fill the gap? But just hold on to that. Hold on to your thoughts on that. We're also joined by Joseph Kpemka, former Deputy Attorney General. Mr. Kpemka, a very good morning to you. Thank you so much for joining us here.
Good morning, my brother. Good morning to the Honorable Ayariga. Good morning to your cherished listeners, and thanks for having me.
Great. The Supreme Court ruled yesterday on the first case of an interlocutory injunction on the e-levy, and they said no way. In fact, in delivering part of their reasoning, they said it would cause quite a bit of hardship to the state. And they are also suggesting that if the e-levy is declared unconstitutional and null and void in the substantive case, then a refund would be given to people. I know... How do you reflect on that ruling? Because others too have said, like you've heard Mahama Ayariga say, he says he doubts that the state would have the capacity in the current economic situation to even give a refund if we get there.
Thank you very much, my brother. And when the rate was filed, I was called to another sister station and I commented on the matter.
Right.
And I did some analysis. But it does appear to me that the opinions I expressed are reflecting clearly in the ruling of the Supreme Court on the matter of the injunction. Oh,
so what you foresaw is what the Supreme Court has said?
Absolutely. In fact, verbatim, I must say. Because, you see, the Honorable Ayariga, a brother of mine, knows that there are some basic principles that guide any court in the grant or refusal to grant an injunction.
Right.
And the courts have never departed from those basic principles.
Right.
Those basic principles are that, one, whether or not the grant or refusal to grant will cause an irreparable damage to one of the parties.
Right.
Now, this irreparable damage principle is very clear. Whether at the end of trial, when a party succeeds in vindicating its rights or getting its relief, ordinary compensation in the form of damages or etc. could be enough to assuage the suffering of the person. And also, they have this other principle, which the courts have time-tested, also applied. Whether or not, in the circumstances of the matter, the grant or refusal to grant the injunction could prejudice the outcome of the main case itself, and etc. In fact, there are quite a number of reasons they consider. But what I looked at was, you see, if they had granted the injunction and they went into stopping the implementation process, and at the end of the day, the fundamental question which the court raised, and which I agree with them without adding a single word, is assuming the state succeeds when the injunction had been granted. And so for the period that people did transfer money, you can never, ever recover that which has been lost. That is irrecoverable. Flip it on the other side. The court says, and I agree with them again, that should it happen that the plaintiffs succeed in asserting their rights and winning based on the relief they are seeking in the honorable court, an order of refund can be made. However difficult you think the implementation process is, the telecos, and then the companies that have been mandated to do the collection will come to put their heads together, and of course, it's technology, be able to refund to the various individuals who transacted within the period. So that is possible. You may argue that it will be a Herculean task and it is difficult, but it's possible. But the other one is not possible, because remember that you cannot, after the end of the judgment, say that, look, all those who transacted between this period and that period when we were supposed to implement and it wasn't implemented, government go collect money from them. That would sound ridiculous.
Because the law in itself is also not retrospective.
Absolutely. That is the constitutional principle.
Right.
So what they have said is sound, and I don't think that we need to belabor the point. What is important is that that was without prejudice to the outcome of the substantive matter. Because the substantive matter itself has to be dealt with. And if they succeed, as I indicated, in proving their case before the Honorable Court, their rights will be vindicated. So it doesn't actually hurt the case of the plaintiffs in the circumstances of this matter. So I think that in discussing it, we need to situate it within the context of time-tested principles for the grant or refusal to grant an injunction in any court.
Right.
And those are the principles the court actually applied in this matter.
And we are very grateful for the context because, yes, as we know, there is quite a bit of a yardstick when it comes to granting injunctions because it shouldn't be to too much of a detriment or the detriment of one party. You've stated that clearly. But interacting with Mahama Ayariga, he also makes mention of the fact that for the substantive case about whether this entire approval of the bill, passing it into law, was legitimate, he says he is optimistic that they would get a ruling in their favor in court. What do you make of that?
Well, I think, my brother, again, somebody I respect so much and I love so much and I admire so much as a brother and a friend. I think he has veered into the arena of sub judice, unfortunately, because he's prejudicing the outcome of the case. Unfortunately.
But wait, Mr. Kpemka, you're saying he's prejudicing the outcome of the case, but when you were on a different platform espousing some of the thoughts that the Supreme Court has now espoused, that was not,
Hold on. You see, the Supreme Court has been very clear that parties today, I'm not a party. I'm not in the Attorney General's office. I am not part of the plaintiffs. I can critique.
But you're a lawyer all the same. You're a lawyer all the same. And a former deputy AG, what you say carries a lot of weight.
I do agree with you. So what did you hear me say? That I discussed effectively and concluded, because what I did was that, let me tell you, I gave out in that analysis I told you, the basic principles for the grant or refusal to grant an injunction. And I situated it within the context of the matter, but I didn't judge that, therefore, this party will lose and this party will win. But I gave it within a context. Context means that I explained the principles for the grant of an injunction and situated it within the facts of the present matter. But that's not even the matter, because the Honorable Ayariga did not go to court to lose anyway. He didn't go to court to lose. He went to court to win. The point is this, that the substantive matter itself, and again, I'm going to raise issues that I'm not going to draw any conclusions at the risk of sounding sub judice. Now, when you look at the particular circumstance of this matter, and again, if you look at the operations of Parliament, you either do voice vote or division and etc. And the time when somebody calls for or challenges that there is no quorum, same is taken into consideration and the number of persons present is counted and recorded. Now, in this matter, they started with quorum. I think 160 plus MPs were present when they started. Now, at the time the question was put, was there a challenge and leading to a situation where they recorded the number of persons who were present at the time the question was put? fundamentally, was there a challenge? And did the Honorable House record that at the time that the question was put, there were 136 members or 135. The reason I'm saying this is that if you come to that conclusion and it's not on record, it remains in the realm of speculation and conjecture. That's the point. So when you conjecture and speculate without specifically stating on record what is recorded, it means that you are not doing your case any good.
Okay, so
Okay?
Mr. Kpemka, just to conclude, in maybe some 20 seconds or less. So on the back of what you've seen, as far as the injunction is concerned, are you optimistic, or do you think that based on the facts available, you will sail through and the e-levies implementation will continue?
Well, I'm not able to draw that conclusion. I leave that to the court. But from the discussions that we are having, the public can come to that conclusion on their own. But
Okay.
I can say that, well, the parties are there and they have the opportunity to vindicate their rights. They should be given that opportunity, and the Honorable Court has so done. At the end of the day, the Honorable Court is going to arrive at the decision based on facts and law. Facts and law. They will look at the facts on the ground in Parliament, what reflected that day, and they will apply the law as they have rightly invoked under Article 102 and 104 to vindicate their rights and etc. So I have no qualms with it at all. And as I've indicated, I'm unable to come to a definite, conclusive determination on the matter because
and I
am not the
understand
court.
you. I understand you.
Yes.
Senior, thank you so much for joining the conversation.
It's been my pleasure, my brother.
Right. Joseph Kpemka is a former deputy AG. I'll conclude with Mahama Ayariga, who is still with us. So I remember I had posed that question about what your alternative would be to the e-levy to fill the revenue gap very briefly, and please deliver your concluding comments as part of that, maybe in some 2 minutes max. Do we have Mr. Ayariga with us? Hello, sir. Can you hear me, Mr. Ayariga?
Yes. Can you hear me?
I can hear you now. Did you get the question?
Yeah, but I thought I answered that question. I told you that if we just manage ourselves more efficiently, we'll be able to cover the revenue gaps that not imposing e-levy will address.
Okay.
We should just connect our revenues more efficiently. We should cut down on wasteful expenditure.
Okay.
And we should just be inefficient in the running of our country. And I'm sure that we'll be able to make up as much as, e-levy could bring into the tax basket. So that question has already been answered. I mean, everybody has spoken about it. Experts have spoken about that. Development partners have spoken about that. That is something that everybody knows. It's just the way that we run our system. Oversized government, a huge wasteful expenditure, and tax collection systems that are so porous that a lot of cracks and a lot of transactions are going through. Tax holidays, tax exemptions, all those issues.
Okay.
If we just dealt with them alone, we'll be able to make up for what we'll get from e-levy.
All right. Thank you so much for joining us. But again, this just comes to mind. My sincere apologies. I didn't think of this. The TUC is saying we should scrap petroleum taxes, all of them. Mr. President says it will amount to about 4 billion. Do you think that is something that your party, if you were to come to power, would jettison or get rid of, the taxes on petroleum products?
I don't announce party policies in television conversations. Party policies have to come from the top.
Okay.
And so I'm not in a position to declare a party position. I don't have that mandate in this discussion to tell you what the party position will be on petroleum levies.
Perfectly understandable. Thank you for joining the conversation. Mahama Ayariga, MP for Boku Central, and one of the three, the triad, who put that motion before the Apex Court. But also joining the conversation, political scientist at the University of Ghana, Professor Ransford Jampo. Prof, a very good morning to you. Hello, Prof.
Hello.
Yes, I can hear you now. Because of where we started, I'll just take your quick thoughts on the latest Apex Court ruling saying that the injunction, as proposed by the NDC, in terms of the E-Levy cannot hold. And their justification, the court's justification, in our opinions, greater hardship will be caused to the state in meeting its developmental obligations to the people. And it suggests if the E-Levy is declared unconstitutional and null and void, the sum deducted could be refunded by the GRA. On the other hand, if the levy is injuncted by this court and at the end the applicants fail in their substantive case, which has to do with the validity of the process in Parliament, the GRA will be unable to recover the levies applicable. Your quick take on that?
Well, thank you. I think this may be a well-reasoned judgment from the judges of the Superior Court of Judicature. But I have a little problem, and I think there is a serious problem in Ghana now. Take note of this, that the NDC has been acerbic in its criticism of the judiciary, especially the unanimity with which they give their judgment, and yet still find the court as a place to go seek resolution of matters, tells us that the role of the court in preventing us from living in a jungle situation is indubitable and crucial. The courts are the only institutions that we have that can keep all of us together and prevent lawlessness. Unfortunately, there appears to be a perception of compromised judicial independence that is being deepened by the conduct and attitude of the ruling government and some of its officials. Now, they now have the penchant for publicly predicting the outcome of court processes, and their predictions have always come true.
When you say they have the penchant of predicting court decisions, whom are you referring to?
Well, you don't need a soothsayer to tell you this, but before this matter was decided, and then in the lead up to the decisions given by the court to other petitions that had been given brought before it, you had senior government officials publicly and openly telling Ghanaians that this matter will not go anywhere or this matter will go in a particular direction. And I'm thinking it is not good. See, the NDC may well have no case, but the way a manner government officials publicly predict outcome of court processes with certainty ahead of judgment fits into the perception of compromised judicial independence. Given the situation, you see, the predictions may be true. The other side or these government officials may well know the law and they can be able to say, well, this is how things may go. But given the fact that there is a perception of compromised judicial independence, you don't deepen that perception by making
so in other words, the public pronouncements must stop.
Even if you know how the matter is likely to go, they have no business coming out publicly to make such predictions. Because if you do that, then it tells people, those who have already a poisoned mind about the judiciary, that look, something untoward is going on. And I'm thinking that given the situation in which we find ourselves, the court must assert itself by finding a way to deal with these government officials who make such public pronouncements and predictions ahead of their judgment. Because it doesn't help. It doesn't help the quest to promote judicial independence. And I'm thinking that rather than the courts over the years being aloof about some of these things, they must also come out publicly to be heard on these matters because it doesn't help them.
Okay, very quickly on this one. So just last month in April, you said to me Ghanaians are losing confidence in the judiciary on the back of some of these matters. Do you feel this 7-0 ruling and the talk shop about it before the ruling goes to increase this perception?
Definitely, that's what I'm trying to say.
Okay.
The point is that I do not understand why some people who are very much seasoned in politics all of a sudden cannot act in a manner that can be described as politically appropriate. They are not being politically smart. And their comments in the lead up to court judgments are not politically wise. We are not talking law here. We are talking about politics and political science. The point is that given the situation in which we find ourselves, whether you like it or not, many Ghanaians or some Ghanaians are losing confidence in the judiciary. And you do not help matters by giving your own judgment and predictions ahead of time when a matter is before the court, especially when you are coming from the ruling party. You don't help matters. And so the practice where senior public officials and government officials will go and say this matter is outmoded at best, it will not go anywhere, and then truly the court would also give a unanimous decision in a manner that is akin to the predictions that may have been given, would always hurt the quest for us to get judicial independence. The judgment, I'm not questioning the judgment of the judges. If you read, the snippet of information that he gave to me tells me that, look, the judges have looked at the matters and they've given well-reasoned judgment. But the point is that every time these judgments will be in tandem with predictions of government officials, then you are not helping the quest to promote judicial independence, because you keep giving the impression that, look, there is something that senior members of the government do that all others do not know. It doesn't help the quest to promote judicial independence.
To wrap the conversation, Prof, I want to pick your thoughts. We have the recent Press Freedom Index, and on the back of it, we've had a lot of comments or commentary from the minorities' end saying that this is the worst we've seen, and the end of the majority saying, no, that's not necessarily the picture, and that we're doing our best. In fact, there was a change in methodology as well. We've heard from Information Minister Kojo Nkrumah, we've heard from Communications Director Yahweh Avena-Asamoah of the MPP. But just a quick breakdown. This latest report pegs it at 60th position in the world. We were 30th the last time. Now we are 60th. This is the worst performance in 17 years. And we've had people come out and say, yes, I'm a journalist. I do not feel safe. I've even seen comments, one Taufik on social media saying, I'm a student journalist and even I do not feel safe. The context of it. Did Reporters Without Borders get it right? Is it a true reflection of what we're seeing in the country? And do you feel the NDC is justified when it says things were better in terms of press freedom during our tenure?
You see, my principled position has always been to be against some of these works and reports from foreigners. What is their locus in Ghana matters? And then also, who authorized them to come and conduct these studies?
Prof, they do this all the time. This is not the first time. They've been doing this for a long time. And it's global. We all react to it. Sometimes they rate the Western countries low.
Doing it all the time does not mean we cannot think to advocate for a halt of their dictatorship. It is neo-colonial for an independent sovereign country to always be dependent on the assessment and the comments and the evaluations of bodies that are found outside the confines of that sovereign state. It doesn't help our quest to assert ourselves as sovereign nation. You don't think that we have bodies in Ghana that can conduct study to independently assess media freedom and press freedom in Ghana?
I know, for example, that the Media Foundation for West Africa, Prof,
rely on assessment from foreigners. You see, regardless of whatever
Prof, just to chip in,
is that foreigners have no business to come and tell us how we are faring in terms of our democracy and in terms of our quest to promote media freedom. They should stay away. We can do that ourselves.
All right. Just to chip in, the Media Foundation for West Africa, for example, has done work over the last how many years? And we all feed into it when they come out with their releases. Sometimes you would hear the CDD as well. But in our local context, and I again mention the Reporters Without Borders is a global entity. So when it comes to our local context, how different would it be? And what bodies would you want to go into this? The NMC?
Well,
the NMC, the leadership of some of these institutions, the problem is that the heads are politically appointed. That is also part of the problem. So which entity does that?
You may see, you have independent researchers in Ghana. Okay? If you come to the University of Ghana, if you come to my Department of Political Science, we do studies that whose findings and whose content would cut across and encapsulate some of these things. And there are credible institutions or CSOs, there are credible non-state actors in Ghana that can conduct some of these studies and churn out results that you mentioned CDD. Okay? They can churn out results that are independent, that we can all describe as credible. I am not going into the content of what these people are saying. My position is for us to be nationalistic as a people and stop pretending that everything we do as a people ourselves are inferior, but those things that come to us, shrouded with some propaganda from outside, are the gospel truth.
So in this instance, do you find it to be propaganda? What it says about the picture of our country?
To the extent that you see, I don't think that they are telling us all the truth. They may have some findings here and there that may be reflective for situations, but the point is that it's not all the truth, and you have to find out their rationale and their motive.
Okay,
and the point that I want to insist on is that we should stop as a people, you guys in the media, we should stop putting a lot of emphasis of some of these findings coming from foreigners. Okay. We are a sovereign nation. Can you imagine? Can you have Ghanaians going to foreign countries to tell them the outcome of their own studies about those countries? What will be the premium that will be placed on those outcomes? And so why is it that for us, anybody can get up from his country and come and tell us some of these things?
But this is not anybody. You see, that is the context.
Even if they reflect the situation, I'm telling you that we have the capacity to do our own studies and unearth findings that will be locally brewed. And we must cherish our own, rather than always going for those things and those findings coming from outside.
Okay, so to conclude, Prof, I just want to find out from you. So what would be your assessment of press freedom in the country currently? Are we anywhere far from what this report says? I mean, what would be your candid assessment when you look at all the things that have happened in our context?
You see, a candid assessment can be done by speaking to pressmen and women in Ghana. When you speak to pressmen and women in Ghana, you sample them and you speak to them, you'll be able to do a candid and an objective assessment of the situation.
Okay.
We are yet to do that. And so we will do that and make our views also. I'm part of a certain research team that is auditing Ghana's democracy, especially under this current regime, and also taking a look at what we have achieved and what our gaps have been for the past 30 years.
Right.
At the appropriate time, we'll come out with some pronouncements, and this is a study that is being done from home. And so we'll be able to do that by speaking to the journalists themselves. And when we speak to the journalists themselves, their verdict would inform our conclusion. And so it is not up to any government official to say that what is going on is not true or it is true. It's not up to the opposition to also say, well, matters are worse or matters are better. It is up to the journalists themselves in an independent study. See, it is up to they themselves to voice out the issues. If they think that things are okay for them, so be it. If they think that they are being repressed or things are not okay for them, it will be something coming from the horse's own mouth. And that is what we can place much premium on, rather than sitting in our country and then relying on verdicts from bodies that are neo-colonial,
Right.
in my view.
Prof, we're immensely grateful that you've taken the time to share these thoughts with us. And do have a good day, sir.
My pleasure.
That was Professor Ransford Jampo. He says it as it is, no holds barred. But do you agree? That's the question. And we'll be going on social media now to find out. Later, we'll activate the phone line. So we're looking at the E-Levy and this bit about press freedom as well, and some of the thoughts that have been shared. Do you agree? Joining me in the studio, Bernice Abubeidu at Lansa. Hi, Bernice.
Hi, Ben. How are you?
I'm okay, but listening to the conversations we've had thus far, I mean, from what you've gathered, what's your take? Look, you heard Prof say that he feels it's neo-colonialist and all of that.
Well, professor of politics, so well, that's how he perceives it. But we know Reporters Without Borders. They do a lot of work in different parts of the world, and so this is their assessment, and they explain their methodology. Government has come to say, based on that methodology, we can't compare this particular ranking to earlier ones, as we've seen happening in the media, and even caution is given in that particular report on how the comparison should be done, and that caution should be taken. So there's a lot of discussion still happening around that particular report. But I mean, we speak to colleague journalists yesterday on PM Express.
He who feels it knows it, huh?
Exactly. Evans Mensah spoke to a couple of our colleagues who also shared their thoughts. But I think what the professor is saying is probably some academic work, that can also be documented and kept. It said this is the assessment by Ghanaian journalists themselves, or the media space they find themselves in. If it's about how we feel in the feedback, we do that every day. I mean, once we come on air, we talk about some of these things as and when they also happen. We bring it to the fore and have discussions with all stakeholders. And so I'm sure it's something, I mean, it's not a bad idea, is it? If we have a report collated by Ghanaian journalists on how media...
It gets me interested, not just the GJA, but we often talk about we're beholden to the Bretton Woods institutions, we're also beholden to... we actually apply when it comes to the Standard & Poor's, the Moody's and the Fitch reports. We apply for them. You're not compelled. But then there's Amnesty International, there are the corruption perception indexes, and then there is this as well. I was just thinking, if we had the Ghana Statistical Service as part of its yearly work, maybe that one I feel a lot more Ghanaians feel safe with. Every year, as part of the basket of issues you investigate, how about you add that when it comes to press freedom?
That's an interesting point. An interesting point to make. Maybe something they would consider. But apart from these issues that we've been discussing, there is also the issue about corruption. Ghana has been trying to solve that problem for quite some time now, and with the introduction of the special prosecutor, there's been a lot of expectation. Have those expectations been met? Well, we'll leave you to tell us what you make of that, because right after this, I'll be having a conversation on corruption. There's a presbyter of the EP Church who believes that the church should be blamed for the current situation in the country as regards corruption. Well, a lot don't agree. Some think she's right. We'll be back to have the conversation shortly.